Welcome to Exam Bites. Let's see today's editorial from The Hindu. Word choice in data protection law, a dilution of rights. Disclaimer, the following views are personal. Introduction. After considerable deliberation, India has finally enacted a data protection law, known as the Digital Personal Data Protection Act of 2023. While incremental progress is favorable compared to stagnation or abrupt leaps, comprehending the true scope of this law necessitates an understanding of its impact on our daily lives and personal privacy. To unravel this, let's focus on two fundamental aspects of any data protection law: the utilization of personal data with or without consent. Consent conundrum. A pivotal issue in data protection revolves around the concept of consent. Does an individual have a say in the usage of their data? For instance, your online activities might be used to study your behavior. An app could deduce personal aspects from seemingly unrelated data points, and you may not want marketing calls despite providing your phone number for a purchase. This is where India's new law comes into play. While it promotes informed consent and requires explicit actions for consent, as opposed to silence, a contradictory provision allows data usage if you've voluntarily provided data and haven't indicated non-consent. The choice of words holds significance. The absence of explicit refusal might be seen as implied consent. This ambiguity poses challenges, undermining the robust consent standard. Balancing act, convenience versus necessity. However, it's crucial to acknowledge that personal data use can't always be contingent on consent. Situations involving identity verification, welfare benefits, and law enforcement might necessitate data access that individuals could withhold. But should such data remain unprotected? Previous iterations of the law allowed non-consensual use of personal data only when it was necessary for specific legitimate state functions or emergencies. The data handler had to demonstrate that alternatives were unfeasible. This underscores that while consent might be inconvenient, it remains feasible in certain cases. But the 2023 law alters this balance. It permits processing without consent if it's for, rather than necessary for, specified uses, substantially altering the protection level. Unintended implications. Furthermore, when data is processed without consent, individuals aren't informed or empowered to rectify incorrect or unnecessary data. Data gathered for one purpose might be freely used for others, despite the Supreme Court of India associating principles like necessity and purpose limitation with informational privacy rights. Critics have also raised concerns about the law's impact on rights like information and free speech, surveillance oversight, and regulatory frameworks. While these might seem like legal nuances, they actually represent conscious choices that weaken rights that could have been safeguarded. Conclusion, a call to action. If we aspire for meaningful data protection, addressing these shortcomings is paramount. Finding solutions to these issues will determine the effectiveness of this law in safeguarding personal data. In essence, our endeavor should be to fortify and preserve the balance between personal privacy and legitimate societal interests.